So I'd like to begin by thanking Beth Webster and the other organizers for inviting me to this conference and allowing me to talk about my latest obsession, which is trade secrecy. A quick look at our schedule reveals how much consideration we all give to patents, trademarks, and copyright. Trade secrecy has received much less attention from scholars, and that's true even though it is, as I'll show, of increasing interest to legislators around the world. To be sure, it isn't easy to do research, particularly empirical research on trade secrecy. The right, after all, hinges on secrecy. But until now, jurisdictions have split dramatically in their approaches. Accordingly, there's considerable opportunity for comparative studies that could help determine whether trade secrecy protection encourages R&D and improves social welfare, as its advocates claim, or whether it interferes with information exchange and hampers development, as my own intuitions suggest. So tonight I'll start with a little background on trade secrecy protection, offer an explanation for why lawmakers are suddenly so interested in it, and set out the reasons I regard it as a threat to innovation, and also reasons why I may be wrong. I'll show you some data, of course, and then end with a look at the EU's new Trade Secrets Directive, and I'll use that to discuss how a more robust understanding of the impact of trade secrecy could help member states resolve the interpretive issues that are sure to come up at the implementation phase of this directive. Now, admittedly, trade secrecy protection is hardly new. In 1817, one Mr. Newberry sued over unauthorized distribution of Dr. James's allegedly secret recipe for fever powders. Similar actions were being brought in the United States as well, albeit typically in state, not federal courts, the courts in which copyright and patent litigation occurs. Theft of confidential information was also considered a problem in civil law countries. For some, Germany, for example, it was regarded as a criminal matter. By 1900, however, the countries of the Paris Union agreed that one way or another, honest commercial practices needed to be maintained, and they amended the 1883 Paris Convention accordingly. First, as you see in this very general provision, the current version has considerable more detail. Note, though, that the provision speaks of unfair competition and honest business practices, which could be interpreted to mean trade secrets. However, all of the examples are about presenting goods, not learning their composition or methods of manufacture. That imprecision changed in 1994 with the adoption of the TRIPS agreement. It references the Paris Convention, but adds a formulation with which American IP lawyers are certainly familiar. It requires members of the WTO to protect against misappropriation information that is secret in the sense that it's not generally known, that has value because it is secret, and has been subject to reasonable steps to maintain secrecy. Interestingly, however, things did not change much in the immediate aftermath of TRIPS. In the US, trade secrecy law was, as I said, mainly state law. A federal criminal statute, the Economic Espionage Act, EEA, was enacted in 1996. This is a tiny bit of it, but there were very few prosecutions. The statute was adopted at the end of the Cold War when the fear was that those KGB types would be looking for new things to spy on. Once it became clear that some version of war was never going to end, that concern abated. So as of 2012, there were only 124 EEA prosecutions in total. In the EU, each country went its own way, and some WTO countries never conformed their law to the TRIPS requirements. Then suddenly, in the last decade, things changed dramatically. So every year, the United States issues something called the Special 301 report, listing the countries that are not, in the U.S.'s view, providing adequate copyright, patent, or trademark protection. It basically functions as a threat: conform to our views or lose your trade preferences. I have the 2012 report up here, and you can see that in that report, for the first time, complaints about trade secrecy protection, or the lack thereof, were voiced by the U.S. Trade Representative's Office. At around the same time, the U.S. began to consider trade secrecy theft a national security issue. It created a counter-espionage unit within the FBI, which has busily generated lots of reading material. And the FBI even made a Hollywood-style movie, which you can watch on YouTube. Not surprisingly, indictments and prosecutions have increased markedly since. And this past May, the U.S. amended the EEA to create for the first time a federal private right of action. Two other things happened in the past year. In April, the EU promulgated a directive on trade secrecy, which is to be implemented by the member states over the next 2 years. And last October, the Trans-Pacific Partnership Agreement, the TPP, was concluded. Likely a harbinger of other mega-regional agreements, it reiterates what Paris and TRIPS require, and then it adds a wholly new obligation to enact criminal trade secrecy law. So considerable activity in the last few years, which provokes the question, why? Why suddenly so much around what was once something of a backwater? There are several answers. First, the changing status of patent law. Several countries have enacted doctrines that reduce the availability of patent protection. The U.S. has strengthened the non-obviousness requirement. The U.K. might have as well. Canada's promise of the patent approach raises the utility standard. In the U.S. and Australia, genes are no longer patentable subject matter. In the U.S. and EPC countries, it's difficult to patent software. In the U.S., diagnostic patents are now a hard sell. The EU also has some limits on infringement liability in gene patent cases. Second is the effect of profound technological changes. The internet, the cloud, collaborative platforms like Dropbox and Google Docs put a great deal of sensitive information onto computers. And as the Democratic National Committee now knows, hacking is relatively easy. And of course, it does create a national security threat. The question I'm talking about is whether that threat carries over to other kinds of information products. Third are new business models. This aggregation of vertically integrated firms into value chains means that developers must give manufacturers and manufacturers must give distributors the confidential information necessary to make products work, secure marketing approval, and service their customers. Besides, apart from the likes of us, there is no longer job security. Employees move around, and there's a danger that the firm's secrets will move with them. Globalization is an exacerbating factor. When it's easy to take information and use it in a remote location where the use is hard to detect, deterrence must be stronger, hence the interest in throwing people in jails. Globalization also produces jurisdictional risk, the risk that the remote location won't take steps to stop the infringement, thus the move to include trade secrecy obligations in international agreement. In short, it's easy to understand the push to enact more and more rigorous trade secrecy laws. Indeed, the data show that while patenting still dominates in most industries, trade secrecy is important in quite a few contexts. The question, though, is whether the recent changes represent a step too far. In fact, the welfare effects of trade secrecy are profoundly ambiguous. On the one hand, trade secrecy protects information from free riders, cheaper than patents. It's the only game in town for unpatentable or pre-patentable inventions. And as mentioned, it allows information exchanges within business relationships. On the other hand, there are many potential costs. As between trade secrets and patents, patents are arguably socially superior because they disclose the underlying technology to strangers. That facilitates cumulative innovation. It allows government to regulate for safety, health, and environmental concerns. Patents also end on a date certain. Trade secrets end when they're independently invented, which requires duplicative research, or when they're reverse engineered, also arguably a social waste. And they may not end at all, or end so late any network effects that were established become too strong to be easily overcome. As Kenneth Arrow has argued, with trade secrets there are also transactional inefficiencies. To sell the advance, the inventor needs to reveal it to strangers, but once it's revealed, the inventor has nothing to sell. And then there's the impact on employment. As an employee, you may be better off staying put. If there's a danger, you'll be found liable for taking a trade secret. Employers can also be liable under these laws, so they may be better or wiser to hire neophytes rather than people with substantial experience, which was gained at a rival firm. Without mobility, salaries in the high-tech sector will be lower and the incentive to invest in human capital diminished. Most important is the impact on information exchange. University scientists, subject to trade secrecy obligations to the owner and the sponsors of their work, may no longer uphold the Mertonian norm of communalism, which is so important to collaboration, to peer review, to converting basic science to technological advancement, and ultimately to progress. Consider also innovation clusters, something ironically governments are working hard to create. Clusters were once largely considered a function of the availability of inputs like clay and fuel, adequate infrastructure, support personnel, and the presence of universities for labor. But several economists have argued that local information policy is also crucial. For example, a comparison of the software industry in Silicon Valley, California on the left and Route 128 in Massachusetts on the right shows that even though both started at roughly the same time, by any of the usual measures of knowledge creation, counting patents, revenue, or as on this slide, firms, California leads. Why? The argument is that it's because Massachusetts enforces covenants not to compete, California doesn't. And California employees can move from firm to firm until they find the best fit with their talents. That not only fosters investments by locals in their own training, it also attracts workers from places where mobility is more restricted. So the red dots, I don't know if you can see them, but the red dots on this slide represent MIT-trained scientists at the firms in question. And if you can see it, you would see that there are more MIT people in Silicon Valley than there are in Massachusetts. As important, the movement among firms within California shows knowledge and skills acquired at one firm spills over to others. In these clusters, there's less exclusivity regarding the use of information, so firms may not be able to protect their market share, but the mobility spreads ideas and improves the technology. The rising tide lifts all boats. Each firm may have a smaller market share, but they collectively share a larger market. And it's not just the firm the employee joins that gains. The firm the employee leaves also is a winner. When an employee leaves for another firm, the original employer gains a new contact, so it may wind up with more knowledge of complementary products, an entree into licensing those products in or licensing their own technology out. It has a new path to potential partners and joint research efforts. In the high-tech sector, what seems to be important is integration into a tight, broad, and deep network. Criminalization arguably exacerbates the problems that trade secrecy can cause. It is well understood that criminal law exerts more deterrence. If the remedy is money damages, one can imagine such a thing as an efficient breach. A worker might pay off his employer so he can take a better job. But high-tech workers can't risk incarceration. They'll wind up never being able to get another job if their skills rot away in jail. Even getting indicted can be a problem. Second, experience with the EEA shows overreaching, particularly into academia, and rampant racial profiling, particularly against Chinese scientists. This is a little bit of a longer list. Most important, take another look at the TPP. It provides so many options, every state can find something it's comfortable criminalizing. But what the TP doesn't do, which international law usually does do, is create a minimum standard, a degree of harmonization. Raising the question, why is this provision there? I submit it's about generating a new norm. The point is to express social condemnation of unrestricted information exchange. So those are the reasons for my concern about the recent emphasis on trade secrecy measures, why I think that vigorous enforcement of trade secrecy law could, in the name of protecting current technology, handicap future development. But the truth is we really don't know. In fact, when I show this innovation cluster slide, somebody always points out that there are many other differences between Silicon Valley and Route 128. MIT and Harvard were not as quick as Stanford to establish a computer science department. There was the Homebrew Computing Club, a group of Northern California enthusiasts who freely shared information until commercialization became feasible. That most famously gave birth to Apple, but to other pioneer firms as well. And besides all of that, the weather is a lot nicer in Silicon Valley, so that's where the MIT folk would rather be. I think that there's a potential project for someone to see whether tech development slowed in the period from 2005 to 2009, roughly that period, when Apple, Google, Intel had their famous agreement not to poach each other's workers. It would also be good to know more about the other theoretical concerns that I mentioned. Norms, does criminal law really instantiate norms more thoroughly than civil law? Is there still an academic norm of communalism anyway? Disclosure, would there be more of it if no one could fall back on trade secrecy protection? Arrow's disclosure paradox, really great theory, but in practice people actually do manage to license. Researchers at the OECD built a trade secrets protection index to see if there was a correlation of higher trade secrecy law with economic performance. And they found a rough one. You can see it on this side if you look at the countries that are at the high end of protection and which countries are at the low end. They also plotted R&D as a percent of GDP against that index, and there's sort of a correlation there too. You have to squint to see it. But part of the problem may be that they disaggregated only very general factors. But in truth, whatever literature is out there is decidedly mixed. So I'll end with the EU directive and use it to show you why knowing more about the impact of these factors, not just these 5, but the disaggregated bunch of factors, and so their components, would help countries implement their law and aid courts in interpreting it. So the first thing to see about the directive is how conflicted the drafters were. One of the first recitals acknowledges the importance of open innovation, collaborative research, wide dissemination of knowledge, and employee mobility. And the very next line, trade secrets have an important value. You can also see it in Article 1, which first establishes the rule of protection, but immediately states that nothing is to restrict employee mobility. Maintaining that balance will require careful attention to several factors. So just to give you a few, consider Article 2's definition of trade secret. First, what does it mean for something to not be generally known or readily ascertainable? Specifically, does it mean that the secret can't be reverse engineered? That is, what if the information could be reverse engineered, but that's not how the defendant acquired it? Is the taking still actionable? The less that's considered a secret, the more muted the impact of the law. Second, what's considered value? Does knowledge of dry holes, things not to try, constitute value, or is that sort of thing, knowing what doesn't work, to be considered part of the employee's skill set? Law that considers dry holes a secret will be much more restrictive in mobility than law that doesn't. Third, what are reasonable steps to keep the secret? In particular, must employees sign confidentiality agreements? If they must, then the agreement serves as notice. Employees can bargain for higher salaries if they know they're trapped and unable to publish. Balance will also depend on what counts as misappropriation. Article 3 spells out what kinds of appropriation are lawful. Notice that B is about independent invention and makes it a defense, which suggests that perhaps information that could be reverse engineered but wasn't is a secret, and getting it could be considered misappropriation. But the main issue here is D, what other practices besides independent invention and reverse engineering should be considered lawful. Article 4 on unlawful appropriation takes no position on inevitable disclosure, an issue in which the U.S. states are very thoroughly split. If the plaintiff has to show the information was actually used, there are ways for the employer and employee to protect themselves. But with the presumption of use, they're stuck. Note that Article 4 also imposes tippee liability. That is, it also regards as liable a person who receives information from a misappropriator. In the U.S., there's theoretically tippee liability in the context of insider trading under the Securities and Exchange Act. But courts are very hostile to it. They worry that excessive liability will deter research and impoverish the knowledge embodied in stock exchange prices. A similar danger is present here. The more concerned a firm is about the information it's using, the less it is likely to send employees to conferences, allow them to engage in other information exchanges, or for that matter, the less likely to hire employees with experience. For innovation, there's a second problem. What if the tippee invests in bringing the information to market and then learns that the information was acquired by improper means? What happens to that investment if injunctive relief is ordered? The directive makes an interesting move here. If the tippee didn't know, I assume at the time of investing, then the judge can award monetary damages in lieu of injunctive relief. The statute, however, is silent on how to calculate those damages. In the patent and copyright context, there is a growing literature on damages in situations where licensing is mandatory. It would be valuable to transpose that work to this context. Work on damages would also be useful on remedies questions more generally. As you can see, the directives gives courts substantial leeways and allows them to include non-economic factors such as moral prejudice in the damage calculation. But it would be interesting to know more about what the impact of awards in excess of harm would actually do to innovation. At the end of the day, the directive gives both member states and courts considerable discretion in devising measures and implementing it. The case has to dismiss if the revealing the secret turns out to protect a legitimate interest. In addition, the measures must be proportionate. The drafters of the EEA clearly knew that trade secrecy can harm innovation as much as it can encourage it. With a greater understanding of the underlying economics, the law could be administered even-handedly and in the way that the drafters intended. So I think this is an important research area, and I hope I've interested more of you in undertaking it. Thank you.
Okay, well, it's great to be here, and thanks very much to the organizing committee for the invitation. I'm going to talk about the dual frontier of both scientific advance and practical application. This is joint work just this summer. This is sort of what I did with my summer vacation with a new postdoc of mine, Mohammed Ahmedpour. Okay, so by the dual frontier, I mean the frontier of inquiry that drives both better understanding and also use. So a typical dichotomy, if a little bit simplistic, looks like this. We think of scientific advance, or what I'll call scientific advance here, as advances in understanding of reality. Typically, the output, the actual knowledge output that's codified would be a research article, a journal article, or what I'll call a paper tonight. And we think broadly on the institutional side that these are going to be the provenance of universities, public labs, to some extent firms, maybe some prominent firms we could think about, who have had important labs driving human inquiry. And then we also have use, or practical application, which we'll think of as called technological advance. These are advances in use, often codified in patents, might be codified other ways, such as in trade secrets. Going back to Rochelle's talk, although as you alluded to, it's very hard to get empirical measures of these secretive things. They're sort of the dark matter of invention and innovation. So I can't say much about them. So I'll be looking at patents. But I think we think patents are important too. So that's worthwhile to look at. And of course, here we tend to think more of private sector actors looking for property rights. Although of course, universities have gotten into this game, as have government agencies. So we want to think about them too. And the broad question that's been in my mind, and I think there's a big literature on this, is how exactly are these advances linked? Does sort of understanding lead to more application? How does application and use drive understanding? The aspect or the direction I really want to focus on, and what I'm going to show you today, is to what extent do scientific advances in our understanding, drive, and support technological advances in use. Okay, so the sort of straw man sometimes, but sort of mainstream paradigm here is the so-called linear model, where we think of scientific advance as a foundation for technological advance. There's sort of the strong linear model where we think people would claim, and I don't think anyone really believes this, that you need to have understanding before you can have application, and that they sort of come in this order all the time. That would be the strong version. The weak version would just be that, well, maybe a lot of the time understanding helps in application, but then how much? Is it important or not? There's certainly prominent examples in the history of science and technology that seem to go along the lines of the linear model. So, Riemannian geometry, for example, was produced in the mid-19th century just purely as an abstract exercise of higher order geometry, higher dimension geometry. It had no application whatsoever in mind until Einstein comes along 50 years later, and it's the essential tool for general relativity. And then, arguably, we use general relativity every day because it deals with time dilation corrections in our GPS positioning systems. A very common example as well would be sort of extremophile bacteria. So you have these I think from these scientists from Indiana University, Brock et al. In Yellowstone, this big national park in the U.S., tromping around in their boots in the geysers, incredibly hot water, and finding these bacteria that can somehow survive incredibly hot water. Really interesting piece of science, but what's the application? Well, it just so happens that then Kary Mullis will win the Nobel Prize with a patent and insight on polymerase chain reaction, PCR, which uses an enzyme from those extremophile bacteria, and PCR is what we use in gene replication. It's really the core technology of basically all biotech. You can't, in forensics, you can't do any of that without this. So it turned out, both of these cases you have at the root some kind of intellectual inquiry which seems to have no interest even in application, and yet turns out to be essential. That's very much this sort of linear model. And there's Vannevar Bush, who sort of, although he never used the phrase the linear model, is sort of seen sometimes as the father of this view. He's the World War II, a former MIT president, then World War II era founder of the National Science Foundation in the US, wrote The Endless Frontier. He describes science as a, quote, fund of new knowledge from which practical applications can be drawn. So that's one view of the world. The problem is, okay, there's some examples, but is that really what's going on most of the time? This is a very happy view of science, and it's fairly high stakes because this is a paradigm that really motivates a lot of public investment in basic science and applied science in universities and all the support that we tax citizens over to provide salaries for a lot of people in this room and grant money, and then it organizes how, for example, government agencies, direct. So they call this is basic research, that's applied research, that's developmental. There's different ways of different phrasings that different governments use, but this is sort of the paradigm of how we organize our policy and funding. On the other hand, there's enormous skepticism that this is actually the right description of where technological advance comes from. And of course, technological advance, when we get to use, is often where the normative case might be beyond human curiosity, because the socioeconomic gains, the gains in health and prosperity, would really, of course, come only through actual application. So, there's lots of other models that sort of reject the linear model, and a very sort of prominent one these days is Stokes' 1997 model of Pasteur's quadrant. And here he's basically just rejecting the idea that we should think of understanding as necessarily preceding use, but really more that we should think of understanding and use as happening in a causative chain. He sort of thinks of them as orthogonal or independent characteristics that appear more or less together or apart in different research projects and in different individuals. So you could have a quest for fundamental understanding on the left, that would be sort of scientific research, and consideration of use on the top, which we would think of as practical application. And he would put, Bohr, the Bohr model of the atom, that was just pure research. There was no application in mind for Bohr, just trying to understand reality. On the upper right, you've got Edison, who, is patenting all sorts of stuff, a light bulb, et cetera, but is really not that interested in sort of the underlying science. He just wants things that work, is making really no effort at understanding, particularly. And then Pasteur, for whom Pasteur's quadrant is named, is at once is doing sort of industrial work with fermentation and food safety and other things in France, and he's also coming up with a germ theory of disease, which is one of the most fundamental insights of modern of medicine. So he's sort of interested in understanding, he's interested in use, and they're sort of happening together, and you can't kind of cleanly separate them. I think, more generally, we often think that use-inspired research might be really impactful, because by dealing with reality in an application, you might reveal important insights about how the universe works and push scientific advance. But then separately from this is, of course, a lot of other people who are just totally skeptical about whether scientific advance really matters. They sort of think of practical application, tinkerers or otherwise, happening in its own sphere and not really relying much on scientific advance. Okay, so as that's all a prologue, what am I going to try to tell you about that? beyond that simple descriptive theoretical setup. I've been thinking about this for a while. This is a new direction of research for me, but what really is the role of scientific advance in practical application and patenting? And that's a hard question to answer, obviously, but can we try to bring some kind of generalizable data or empirical metric to that beyond sort of our anecdotes that people have been battling back and forth with individuals like Pasteur for some time? So what I've done, and my colleague and I have done, Mohammed, we've taken all the U.S. patents, about 5 million U.S. patents over the last 40 years, and then we've looked at all of their citations to papers. Okay, so and then we've done that by merging it basically with all 32 million research articles in the Web of Science. And the idea is that we can then create a metric to think about how scientific advance could underpin patenting or practical application. So here the orange dot is a patent and the green dot is a paper. Okay, and this is a case where the patent cites the paper. Okay, so there's sort of patents and papers, and this boundary is this boundary between practical application and understanding. Okay, and I'm going to call those a D equal 1 patent and paper, meaning they have a distance metric of 1. The path length from the boundary between understanding and use is 1. Okay, and then I could have other papers that might underlie that D equals 1 paper. So these papers, D equals 2, are not directly cited by a patent. They're cited by a paper that is cited by a patent. And then I could have a D3 paper, kind of further away from the frontier. Okay. And then similarly, I could have D equals 2 patents. Patents that don't cite papers, but they cite patents that cite papers as prior art. And D equals 3 patents, and on and on and on. I can also have papers and patents that just are disconnected. Papers in the Web of Science, patents in the US, that there's no link across this boundary. They just exist only in their own sphere. Okay? Does that make sense? So what I'm trying to do is define D as the minimum path length in a knowledge network. For every single knowledge output in all 5 billion patents and all 32 million papers, attach an integer number D, which defines how far that patent or paper is from this boundary between application and use. Okay? So with that, and I'm going to show you what you can learn. Okay, so the first question is, to what extent do patents build on scientific advances? Are most patents in this network, or are they kind of in their own sphere? Is most science just irrelevant to future patents, or is it mostly integrated? So the first fact is that you have what I'll call majority connectivity. If you look at patents on the right, 60% of patents are in the network that either directly cites or cites patents that eventually cite papers. So there's some precursor scientific advance that is in the intellectual background of this patent application, okay, this advance. 40% of patents exist in a world where they don't connect at all to papers. So there are quite a lot of patents that don't seem to connect to scientific advances, at least in an explicit way, okay, such as measured here. Papers actually conditional on, you have to be cited at least once, but conditional on a paper being cited at least once by another paper, 80% of papers ultimately are drawn on directly or indirectly by patents. Okay, so that actually suggests that the vast majority of scientific, this is science and engineering papers, not economics. Science and engineering papers, the vast majority do seem to ultimately connect to some future practical advance. Okay, so that's sort of, I think, good news at some level for the linear model at some level. But the second fact is that, well, are these close connections or are they distant? And the answer is that they're typically pretty distant. So this is the distribution of D. So, 1 is a patent that cites a paper directly, or a paper that is cited by a patent. So about 20-some% of all patents directly cite papers in the Web of Science. So they directly build on some scientific advances prior art. Less than 10% of papers in the Web of Science are directly cited by a patent. But you can see that most papers have a degree of 2, or maybe 3. So they're a little further from that understanding of scientific advance. And papers are actually further. The modal paper has a degree of 3. Okay? So it's kind of indirect, these relationships for the most part. There are direct connectivity on that frontier, but the majority of patents and papers are not right on that frontier. Okay. I'm offering this D metric because I think it can be useful in a variety of applications. So for one application, you can use it as a metric to compare fields. So if you want to know if certain fields are more or less close to application, as science fields or certain patent fields and technology fields are more or less close to science, this metric can tell us that in the following way. So the third fact, when you look at a field level is that there's enormous diversity. So this also suggests to me right off that the linear model might be a great description for some fields, but it's probably a terrible description for others, and so we shouldn't have a debate about it at the level of all of reality. We should debate about it with some more nuance. So every dot here, just look at the x-axis, is the average D for every patent or paper in that field. So a dot would be, this is a field of patenting, technology class, which average D is like 1.7. And you can see that some are less than 2, some are up over 5. And similarly for patents. So you have some stuff that's really close to the frontier on average, and some stuff that boundary, and some stuff that's very far away. So to color that in, I mean, I think this is sort of maybe not that surprising, but these are scientific fields. These are the distribution of D in different scientific fields. So what do we got? That's mathematics. So mathematics, the papers are typically 4 or 5 degrees. Deep mathematical insights are not going to be drawn on by patents very directly, but they might, through a lot of other fields that draw on that math, ultimately get to the patent frontier. So Riemannian geometry would be sort of one example that might be like that. Astronomy and astrophysics, a bit more applied, but still really pretty far from the patenting frontier. As you're getting to biochemistry and molecular biology, the average paper is just 2 degrees from a patent. They're getting very close to patent applications. And if you see, there's a couple fields who the modal paper, the main papers are actually always degree 1, computer science, for example. So computer science papers, the majority of computer science papers that are actually cited directly by patents. So it's very, very close to application. But of course, computer science papers, what do they cite? They might often cite applied math. And applied math might cite pure math, et cetera. So you can sort of see these, you can peel apart these layers. Okay. If you look at patent fields, these are the 10 closest fields to scientific advance. So I'll just read a couple of examples. But the D in these fields is often like 1.2. So like almost every paper, every patent, in that technology class cites a paper. It's very closest linked to scientific advances. A lot of chemistry, superconductors, a lot of materials, a lot of high-tech mobile or biology, multicellular living organisms. You get some computers, data processing, artificial intelligence. You read that list and think, okay, these are things that sound like they might be pretty closely related and driven by scientific advances. How about the 10 fields of patenting that are furthest from, but still connected to sometimes, to science? That's kind of amusing, I think. Buckles, buttons, and clasps, supports, rasps, sewing, closure, envelopes, wrappers, and paperboard boxes. Okay, so things that probably, to me, this kind of stuff helps me think that this D measure has some face validity, because these strike me as exactly the kind of fields that probably wouldn't be closely driven or aware of scientific advances. Chairs and seats is the least related technology class to science. Okay. All right, so all that, but what about stuff at the boundary between application and understanding? Is it especially important? And the answer is, at least judging by how often things are cited, yes. So here what I'm looking at is for papers and patents, again, arranging all of them by the D of the paper or the patent, how far it is from the frontier, which is right here in the middle. So for patents, we know, from Mel's work and others, that patents that are more highly cited tend to have more market value. Okay? And so what do you see? You see that D equal 1 patents have the highest market value. This is the citations from other patents. Okay? And it's ultimately about twice. As you get away from that frontier, the market value, or I shouldn't say that, but the citation impact of these patents is sharply declining. So it looks like actually the most important patents, maybe, by this measure, are the ones that are most closely interfacing with science. Actually, what some of those fields are just before. If you look at papers, it's the same thing. The papers that are actually, this is how often you're being cited by papers, right? So a paper that is cited by a patent, a D equals 1 paper, is far more impactful in the domain of science. It is also highly cited in science compared to other papers. So that suggests that the stuff that really is at the frontier, at the boundary between understanding and use, is actually the most important in their own domains. Which might go against how you might think of, say, university faculty who might dabble in patenting. Are they sort of going into areas that might not be as important? Well, by this measure, they're both, they're doing stuff that actually looks like extremely important to understanding and future work in science, as well as having applications in patenting. Okay, so getting close to the end. Who's driving the dual frontier? Who drives this boundary spanning connection between application and understanding? And I think this wasn't that surprising to me, but it's also pretty interesting, the numbers. So again, papers, This is data we're still putting together, but I can tell you which papers are university-authored papers and which ones are from firms. These would be CompuStat, publicly traded large publicly traded U.S. firms. That's the dark blue line. So you can see that those guys are closer to the frontier. So not surprisingly, when firms do research and publish papers, they tend to be closer to patenting private property rights. This is a business than you would see with universities. So it is suggested that universities, in fact, are important sources of basic research compared to, say, industrial labs and CompuStat and large publicly traded firms. On the right side, I have patents, and here I can, then more work, so I can tell you if this is the university assigned patent, CompuStat firm assigned patent, or a U.S. government patent. These are U.S. universities. I think the most striking thing, not surprisingly, U.S. universities and government labs are more likely to have their patents be D=1 patents. They're more likely to be doing the practical applications that are directly building on the science. Okay, in fact, 60% of university patents directly cite a paper. Okay, given that we now also know that those patents are highly impactful patents on average, that also suggests again that university patents, which we sometimes worry about, might actually be bringing really important ideas and creating high-value patents out of the corpus of scientific advance. And the last piece is individuals. So somebody is actually, over here in a firm and citing a paper. Someone is a government lab or a university is coming up with this patent and citing some underlying scientific paper. So at what rate do they do that? So take the D=1 patents, the patents that directly cite a scientific advance as prior art. What is the fraction where an inventor also produced the cited paper? Okay, so for universities, over 50% of these patents, the inventor is the author of the paper they're citing. For public labs, similar, not quite as high. For firms, it's only like 14%. Okay, so these are the pastors, right? These are the public institutions seem to have a lot of these pastors who are both doing understanding and use at the same time and doing it in a connected way. Okay, firms, interestingly, seem to be doing more of the looking across or maybe outside the boundaries of the firm. More work to be done on that empirically for me in looking for scientific advances that can drive new applications. And of course, that friction is one that a lot of policy tries to confront. Okay, so to summarize and stop, what I've done here is try to introduce and show a new metric for connectivity between technological advances and scientific advances. I actually applied it at the level of firms, fields rather, until you could organize fields this way, a little bit around institutions. But I think it's a metric that could be very simple, very transparent. Instead of saying something's basic or applied, we can actually put a metric on it, whether it's a field, an institution, an individual, a journal, a funder. Is a funder funding basic or applied, or how close are they to these things? Hopefully this metric can allow us to characterize that in a quantitative way, which I think is useful for policy, among other things. In terms of the models I started with, I think the findings are actually pretty consistent with the linear model, at least as measured this way, in the sense that we saw majority connectivity. Most patents can draw down to some paper, and most papers are in the same common component, citation network, with the patents. On the other hand, it's really indirect. It's typically indirect. And there's lots of diversity across fields. The modal D, distance for a field, could be anywhere from 1 to 6. They're very, very different in terms of how close or far they are on both sides, whether it's patenting fields or paper fields from the frontier between the two. But there's also stuff here that's quite consistent, I think, with Pasteur's quadrant. The idea that closely linked advances to understanding and use do seem most impactful in the domains of science and patenting themselves, which suggests that this interface between patents and papers is especially valuable. And we saw that the last thing I showed you, the last fact, is the same individual is often spanning that boundary, bridging the patent paper frontier in universities and government labs, but much less so in firms. Okay, so those are some facts to try to color in, I think, some old questions in science and technology that hopefully are good and fruitful for your own thinking about universities and IP and all of these, and policy and all of these issues together. Thank you.
Many of my colleagues and friends see me as an obstacle in many ways, so I'm quite used to it. I also recognize that the slower I make my points, the longer it will take us to get to the reception. So I'll try to go very quickly. And I was asked to do a wrap up, and it's quite a challenge because I want to thank my distinguished speakers here because it's fantastic information. It's a great way to open the conference. So I'm not going to wrap up at all. I'm going to say that this is really a fantastic opening for the conference because I think some things were addressed in each paper from a number of different perspectives that I think set the stage very well. For what we're going to be talking about over the course of the next couple of days. So both from sort of a big picture asking really what is intellectual property about, going to the roots of why we have it, and its roots in innovation and its connectivity to science, to practical policy making and recognizing there's a complementarity among the various kind of intellectual property rights that we have in different regimes across the globe. So I think both of these papers were well chosen for that, for those purposes. So it may seem a little bit strange too, because as chief economist at the Patent and Trademark Office, oftentimes we're faced with very, what might seem very, very small questions, very micro level questions about intellectual property policy, everything from examination practice and patents to fees. And fee setting. And I think that fee setting, while extremely narrow, is a great opportunity to think about, again, taking a very practical policy and looking back and tying it to what does what's patent policy there for, right? So we know that it's there to incentivize the innovation, incentivize the creation of new goods and services. How are fees related to that? Well, if we can imagine if we just charge for the at cost for the full search and exam right at the beginning, and then we have no maintenance fees, obviously there's a huge consequence in potential follow-on innovation, right? So patent fees actually I think are rather important. Now I would because that's part of my job, but I think that it helps us always. I'm reminded of talking to certain stakeholders that would feel that's what we'd call them in the U.S. I'm not sure what you call them here. They're the people who are applying for patents and have the most at stake when you're looking at patent policy. When you talk to stakeholders about patent fees, oftentimes many of them feel that we shouldn't use fees, patent fees, to change behavior. And I think it's a bit odd to think about that when the patent system itself is created to change behavior, right? So we're going to give you patent rights, and we need to charge certain fees, and we can charge small fees on the front end and big fees on the back end. We can charge large fees on the front end and small fees on the back end. It's all about modifying behavior because it's all about creating that incentive for the creation of new goods and services. And I think that it tells us just how complex all of these questions are, which is why there's always new research opportunities. And I think I really just want to kind of sum up on what thinking about those research opportunities. I think that Ben's work is fantastic in terms of tying together the science to the technology, because I think that is something that in particular we know very, very little about. And when we talk about IP policy, most of it is driven by the rights that we can observe. Most of it is driven by the patents, the trademarks, copyrights that we can observe. And when we think about IP policy, most of the time it's driven in kind of, I'd say, an asset way of thinking. Patents are assets, trademarks are assets, but they're not an end in and of themselves, right? They're there for a purpose. And I think that what we don't know enough about is that connection to that basic research, which is meant to be not patented, which is meant to have large spillovers, all the way up through something like trade secret, which is really meant to have no spillovers. I mean, that's, if you've got large spillovers in your trade secret, well, you've got problems.
It's the reverse, actually.
Yeah, exactly.
If you have no spillovers, you have problems.
And it goes to, and I think that sitting in between those two things is something that I've seen as a policymaker, and I'll just end there. When we go to NIH and we go to NSF, and they're thinking about the money that they're spending on public R&D, they're always looking for the ROI. They're looking for that return on investment. Because they have a lot of people asking them, what's the return on the public investment? And I guess I want to leave that as an open question. How do we want to think about return on investment for public funding? Do we want to think about those expenditures, those R&D expenditures that lead to the quickest, fastest applications? And that's a question I would also ask you, Ben, in your data, is what can you tell us about lags? You know, and I know that you're just exploring this stuff, and I think it's really exciting, but what can you tell us about the lags? And we can imagine an incredibly impactful scientific paper that doesn't have the application for 20 years, but may have more return on investment down the road than some that have a much faster turnaround time. So I'm going to leave it there, and I'm going to just sort of put that question out there: is how do we want to define return on investment for public funding, but also for private spending? But I want to thank also our speakers and of course our hosts. And that's all I have. So I'm going to turn it back over to Beth and